Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
Please be seated. We'll hear argument in three cases this morning. First is 2033, Pharr-San Juan-Alamo Independent School District versus the Texas Political Subdivision's Property Casualty Joint Self-Insurance Fund from Hidalgo County and the 13th Court of Appeals District. Then 2270, Preston versus M1 Support Services from Denton County and the 2nd Court of Appeals District. And finally, let's see, I think this order is wrong. I think the second case, let me see here. Yeah, I'm sorry. The second case is 21232, Monroe Guarantee Insurance Company against Bitco General Insurance Corporation, a certified question from the United States Court of Appeals for the Fifth Circuit. And then finally, 2270, Preston versus M1 Support Services from Denton County and the 2nd Court of Appeals District. We have allotted 20 minutes for each side in each case, and we'll take a brief recess between the cases. The arguments are being webcast live this morning and will be available in the archives later today. We're ready for 2033, Pharr-San Juan-Alamo Independent School District against Texas Public Political Subdivision Insurance Fund.
The court, Mr. Campbell will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court. I meant what I said, and I said what I meant. An elephant's faithful 100%. The court could have said something very like that last year when it decided the Richards case and the Avalos case, but instead of simply relying on precedent, and which is clear, over 50 years ago this court announced the 8 corners rule, was clear about what the court meant when it said that the 8 corners rule would apply. And since then has explained, refined, and developed that rule. Nevertheless, the court did not merely rely on stare decisis and this court's previous cases, which are in tab 1 of the bench book. Instead, this court did something that I think is really critical for the jurisprudence of the state, and dug into the 8 corners rule and asked the question, where does it come from? And in Richards, the statement by this court that the 8 corners rule is not a creature created by the court, but it's a creature of contract, just hit me over the head, and was so important to the jurisprudence of the state. And I think it's important to the 2 cases the court will be considering today, because I think that what the court did in Richards and in Avalos in clarifying and stating that the 8 corners rule is a creature of contract means 2 important things for these cases. First, it means that a judicially created extrinsic evidence exception is unnecessary. It's unnecessary because the good news for insurance companies is if it is true that an insurance company believes that the 8 corners rule results in manifest injustice and raises premiums, then of course an insurance company can offer a policy that has some kind of extrinsic evidence exception, and the good news for policyholders is that presumably that policy will have a much lower premium. The second important result of what this court said in Richards and in Avalos is this. Not only is an extrinsic evidence exception unnecessary, it really goes against this court's jurisprudence, which shows respect for the party's contract.
Wouldn't such an exception be more efficient?
Absolutely not, Justice Lehrmann. I actually think the opposite would be true, and here's why. One of the most important things that the 8 corners rule does is it focuses the party on the underlying lawsuit against the insured, and it avoids ancillary litigation over the duty to defend and brings those issues. Just look at this case, right? This is a case where under the Texas Tort Claims Act, the underlying liability was capped at $100,000. And yet, if you look at the judgment in this case, attorney's fees alone, just for the school district, are more than $100,000. If you add in the attorney's fees that the insurance company has spent on this case, which was filed back in 2013, you're looking at attorney's fees that are now double or triple what the underlying liability would have been.
Well, wouldn't it really encourage artful pleading? Because if the plaintiff, say, for example, knows for some reason that they're not covered, but they're vague in their pleadings, then the insurance company would have to defend, even though in the long run, they may not, it may turn out that the facts show that they didn't have to defend. Those facts don't have anything to do with the underlying cause, but, got a free lawyer in the meantime.
Absolutely. Yeah, so I understand the court's question, and I think that is a concern, and certainly that happens. But I think I would say three things about that. First of all, obviously, the policyholder has no control over how the plaintiff pleads the case. And so to the extent that there is artful pleading, that is not something that is in the policyholder's control. Second, the insurance company has control at the front end, instead of after the fact, second guessing whether or not it should provide a policy based on, or a defense based on the pleadings. Beforehand, if that is a concern for an insurance company, they can address that concern in the policy. And third, if you're looking at the policy, every insurance policy I've seen that has a duty to defend clause first has a duty to indemnify clause that is worded in a way that clearly triggers the underlying facts, and second, a duty to defend clause. And importantly, if the court looks at the clause in this case, it's like the clause in many cases. The duty to defend is not just an obligation, it's a right that the insurance company has. And I can tell you that having prepared coverage opinions in the past, there on more than one occasion, I have told an insurance company, I think you've got a good argument that you don't have to defend this case. Even under the 8 corners rule, taking all facts in favor, liberally construing them in favor of coverage, I still think that you could deny a defense. And I've had insurance companies say, well, we understand that, but we would rather provide the defense because it's a right. And it gives them the ability to control the litigation, which allows them to control litigation costs, and also ensures that they won't have a crazy judgment entered against the insured that they might be on the hook for later.
Mr. Campbell, you said that the insurance company could handle this on the front end if it chose. Did the insurance company in this case handle it on the front end by expressly excluding anything that isn't principally designed for use on public roads? And wouldn't that be one way of handling it, is saying this automobile policy doesn't cover anything that's not principally designed to be used on public roads?
Sure. So if we get past the duty to defend and look at the coverage issues in the case, and I should say, of course, there are a number of other issues that have been brought up before the court in this case, and I'm happy to answer questions about those, but wanted to focus on the duty to defend. As to the coverage provisions in this case, of course, there is an initial auto definition that allows for coverage of any land motor vehicle designed for use on public roads. And I think our position has always been, and I think the evidence in the case shows, based just on how the terms are used, that a golf cart is designed for use on public roads. If you go down to the 6 or 7 exclusions in the policy for mobile equipment, that is where you get to the language about whether or not a vehicle that is principally designed for use off public roads is excluded or not. And that is where, in this case, what we try to focus on from the very beginning, and I think you can see this in our summary judgment motion, you can see it in our argument to the trial court, was on whether golf carts, as that term is used, are always designed principally for use off public roads. We have never taken the position that every golf cart is designed principally for use on public roads. Instead, we think the relevant coverage question is whether, when you use that term golf cart, are there some vehicles out there that you'd look and say, hey, there's a golf cart driving down the street, and is that designed for use on public roads? And that is why we went not only to dictionaries and treatises like this court has done before, but went to see how that word is used commonly in the vernacular, in common speech. And so that evidence is in the record. The Court of Appeals...
Does the evidence indicate whether there's ever a vehicle a golf cart that's designed for use principally off public roads? That's a different question than whether it is designed for travel on public roads.
Right.
But whether it's principally designed for use off public roads.
And so that's why to trigger coverage here, the language was whether it's designed for use on public roads. There, I think we clearly triggered coverage, and not only under the duty to defend, but also moved for traditional summary judgment and no evidence summary judgment on the duty to indemnify. And that's it, I think, 816 of the clerk's record that you can see that.
But it's the definition of mobile equipment that kind of where the rub comes.
That's right. So if we go to that definition of mobile equipment, that is where I think it was important for us to look at how the word is used, how the word golf cart is used, terms and usages. And frankly, I think the way that the term is used today may be different than it was used 50 years ago. And so that's why we looked at not how it was defined 50 years ago, but how it's used today. And the Court of Appeals, in its opinion, reviewed that evidence. And in the Court of Appeals' opinion, I know the court's read it, and the court has seen that the Court of Appeals said that we made that case. That based on what was in the record, we had shown that it was reasonable for an insured to believe that a golf cart was covered under this policy. Specifically, the Court of Appeals said that we showed that there was potentially coverage.
So can I back you up on that? Focusing only on duty to defend. So accepting your argument that no extrinsic evidence is allowed. So you have the allegation that she was injured because she was thrown off a golf cart. And then you have the policy saying we only cover liabilities arising out of use of an auto, which is something designed. On what are we looking at to conclude under your approach, Eight Corners approach, what are we looking at to conclude that a golf cart is designed or might be designed for use on public roads?
So I think that gets to the extrinsic evidence or the exclusion issue that's before the court. And our view is that the court should look at whatever evidence is useful in understanding the meaning of the words.
But your whole argument is we should reject the use of any evidence and look solely at the Eight Corners.
So in our view, the Eight Corners rule prevents looking at evidence about the underlying facts of the case. So the Eight Corners rule prevents extrinsic evidence about this golf cart, about this lawsuit. In the same way that in other cases, maybe it would prevent looking at whether this individual was an employee.
So you agree we can look at evidence so long as it's not evidence regarding the golf cart in this case?
So I think and I don't know that the court has been clear about this or that Texas courts have been clear about this. I think it's a semantics issue because we know that the court looks to dictionary definitions, looks to treatises to understand what words mean. And I cited a book that I enjoyed, The Madman and the Professor, about how dictionaries come up with their definitions because they don't, pull them out of thin air. When we write dictionaries, we go out and see how are people using words.
Dictionaries, treatises, I assume prior case law, the way courts have, but can we look at brochures and advertisements?
Yes, I think so.
So you're not arguing a strict Eight Corners approach. You think even for the duty to defend, we can look at things like brochures and advertisements?
If the court views that as extrinsic evidence, then yes, we're arguing for an exception of that. I would say that my view based on this court's precedent, and maybe I'm wrong about this, but my view is that that has never been considered the type of extrinsic evidence that courts discuss when they discuss the extrinsic evidence rule. And that's rooted in the policy language, right? Because when we're looking at the policy language, we're looking at what is alleged, what damages they're seeking, what they're asking for. And in understanding how those terms can be reasonably understood, the courts have routinely looked at, as you say, cases, dictionaries. I don't think that it would violate the extrinsic evidence rule as this court has described it to look at any source that would aid the court in understanding the meanings and usages of words.
So it's a matter of semantics as to whether that is extrinsic evidence, basically. Maybe it is, maybe it isn't. If it is, you agree there should be a limited exception to the Eight Corners rule.
That's right. And
So let me ask you about the evidence here, because I looked through the the brochures, the Easy Go, all that, and the Wall Street Journal article, and none of them, I mean, if you go to their website, you have one link for personal vehicles and another link for golf vehicles. And the ones you submitted are all under personal vehicles, and it never once in any of those refers to it as a golf cart. So how does your evidence, and same thing with the Wall Street Journal article, I mean, the title says invasion of golf carts, so it does refer broadly to, but when you actually read it, it calls them golf cart-like vehicles, neighborhood electric vehicles, electric cars, errand cars, low-speed vehicles. None of your evidence ever refers to those items as golf carts. So how is that even evidence that that's what a golf cart is?
I guess, actually, I was going to say three things. Well, one, I was going to point to the Wall Street Journal article because I think that is, it does refer to them as golf carts. But
It's the title.
But moving on from that, I mean, second, I think if you root this case in the principles that this court has announced, which is interpreting ambiguities in favor of the insured and asking whether a reasonable policyholder could consider a golf cart to include this type of definition. There have been arguments in this case that these aren't really golf carts that we've submitted in our evidence. They're low-speed vehicles or these other terms. I can't imagine that anyone walking down by the Capitol and seeing one of these zip by would nudge their friend and say, hey, there goes a low-speed vehicle. I think what they say is, hey, there goes a golf cart. And so what we're looking at is common usage, and that's why that Wall Street Journal article was particularly persuasive argument on the usage of the term.
We need to disagree with how the Fifth Circuit approaches this in order to rule for you.
Well, which time? The Fifth Circuit has announced different rules. It's interesting that the Northfield exception has gained that name because, as the court knows, in that case, the Fifth Circuit rejected consideration of extrinsic evidence. I think that the court should follow what the Fifth Circuit said in Northfield and saying that we think it's unlikely, given the weight of authority, which we've put behind tab 2 of our bench book, a lot of that Texas authority that has consistently, in our view, adopted the 8 corners rule without extrinsic evidence. And I think the court should follow that. I think there is an opportunity for the court in this case and the next one to clarify both, I think, what the court means when we say that extrinsic evidence can't be considered in terms of the 8 corners rule. As hopefully my back and forth with Justice Boyd illustrated, I think that is something that could be clarified, and I think it should be clarified to say that extrinsic evidence specifically is extrinsic evidence about the underlying facts. And I think the court can be extremely helpful in answering the Fifth Circuit's question and telling the Fifth Circuit that with that definition of extrinsic evidence in mind, Texas follows a strict 8 corners approach.
Any other questions?
I just briefly,
Yes,
with
Justice.
regard to the one satisfaction rule, the trial court didn't consider that. And so it seems that that's a pretty major thing in terms of how much has been paid here. What's your response to that?
If you look at the second volume of the reporter's record, I think it's pages 14, 15, or 16. That is the only reference in the underlying clerk's record by TPS to a settlement credit. The short answer to your question is, in that exchange, TPS asked for the opportunity to amend their petition to assert that. They never amended their petition. The judgment was entered, in this case, without TPS ever submitting any request to the trial court for a settlement credit. And so we would say that issue has been waived.
Any other questions? Thank you, Mr. Campbell. We'll hear from the respondent.
May it please the court, Mr. Hernandez will present argument for the respondent.
Mr. Chief Justice, and may it please the court, I'd like to correct, if I didn't plan on starting this way, but I'd like to correct a misrepresentation regarding the one satisfaction rule. We did ask for leave to amend and filed an amended complaint or an amended answer that asserted our entitlement to one satisfaction as soon as we found out that they had settled with the other insurance company that was defending under the mobile equipment policy. The court granted leave, and what happened is thereafter, rather than amending their responses to requests for disclosures and providing that information, which they were bound to do by law, they just sat on it, submitted a final judgment which the judge basically rubber stamped the same day. Did not give us an opportunity to argue that we still need this evidence.
Did the record ever indicate what was paid by the general liability
The
company?
judgment, it doesn't, we don't know what the co-defendant paid. All we know is what the judgment is. We even tried a route after the final judgment was entered, and while we were waiting for the Court of Appeals, we tried to get it out of the school district through a open records request. Counsel filed an objection for the benefit of the other insurance company, claiming that it was private or proprietary information and exempt from production. So to this day, we still don't know. Now,
You
with,
described the other policy as a mobile equipment policy.
yes.
Was that what it was called, or was it a general liability policy?
No, I think it was a mobile equipment policy.
Didn't that carrier take the position that it did not owe coverage or defense in the case because it should have been covered under the auto policy? At least at one point?
Eventually, that's where they got. Originally, they defended, and they filed a motion for dismissal or plea to the jurisdiction under the Tort Claims Act, arguing that because they were a school district, the only exception is operation or use of a motor vehicle. And they argued that a golf cart wasn't a motor vehicle. They had a really narrow definition of motor vehicle for purposes of that argument, and the motion or the plea to the jurisdiction was denied. So the insurer withdrew their coverage, saying, hey, it's not a motor vehicle, so you need
Just
to
their
go to your
coverage
auto.
or their defense?
Everything.
Yep.
They withdrew. They said this policy does not apply because the court ruled that it was a motor vehicle.
Which is kind of confusing whenever you look at the Tort Claim Act. And so I'm assuming it's what Justice Bland was saying. Then they were saying because that's covered under the automobile policy.
Right. That's what the position that the mobile equipment insurer took. But the case law on that is pretty clear that the definition of motor vehicle for purposes of the Tort Claims Act is much broader than the term is used in other arenas, including insurance coverage issues. So I don't think, I guess they finally came to the conclusion that they shouldn't have withdrawn their defense and their coverage because they ended up settling.
So the duty to defend and the duty to indemnify in the insurance contract, they're not the same. You would agree that the duty to defend has broader contractual language.
Yeah, that's the way the courts interpret it, yes.
So would the rule that you propose make them so that the duty to defend and the duty to indemnify are basically coextensive?
No, I'm not looking for that at all. I am proposing
Okay,
that.
why not? Why not?
Well, the case law, I mean, is it's so vast and so long that they are separate duties, and one duty is triggered by the 8 corners, the policy and the petition and the underlying claim, and that's what triggers the duty to defend, and then the duty to indemnify is the facts of the case can be brought up to determine whether or not there is that duty under the terms of the policy. But the first duty to defend, is currently bound by the 8 corners rule. It's what the insurance policy says and what the plaintiff and the underlying cause of action says happened. And if the allegation, if the petition triggers coverage under the policy, there's a duty to defend. The second analysis comes later as the facts develop in the case. But in this case, and our argument is, first off, and it's the argument we made to the Court of Appeals, and to the court, was that there was never a duty to defend in this case. The policy language, and it's the first excerpt of the first document of the excerpts I gave you, the policy clearly says that, that it is covering covered autos. We're insuring covered autos, and it defines a auto as also coverage will pay for bodily damage, bodily injury and property damage arising from an accident resulting from the ownership, use, and maintenance of a covered auto. And then under definitions, an auto is a land motor vehicle, trailer, semi-trailer designed, and here's the important language, designed for travel on public roads, but does not include motor equipment. And then motor equipment is defined as a land vehicle that is designed for use principally off public roads. So auto on public roads, mobile equipment off public roads. The only allegation in this case regarding the vehicle is in the plaintiff's petition, and the plaintiff's petition simply says that the plaintiff was thrown from a golf cart. And so if PSJA, if the school district wanted clarification, they had control. They were the defendant in that lawsuit. They could have specially accepted and asked them to elaborate. They never did. Plaintiffs amended their petition, but did not change the description of the incident. It was, the plaintiff was injured when she was thrown from a golf cart. We approached this as a 8 corners case. Our summary judgment was strictly an 8 corners analysis. We presented to the court the policy language. We presented the definition of what an auto was, and we presented the pleading that she was thrown from a golf cart. We also presented all of the different statutes in the state of Texas that define a golf cart. Starting with 502.001, a golf cart is designed as, or is defined as, a motor vehicle designed by the manufacturer primarily for use on a golf course. So if it's designed primarily for use on a golf course, then it is not designed primarily for use on a public road.
How are we going to know that?
Because the two definitions are polar opposite of each other. One of them is you can use this vehicle, an auto, on a public road. The other, the statutory definition, is you can use this golf cart on a golf course.
But how do we know about two things? This golf cart specifically, or golf carts generally? You can't tell that from the 8 corners.
Well, originally we didn't produce any evidence regarding this golf cart in particular. We just talked about golf carts in general. And our position was a golf cart cannot be an auto because it is designed to operate someplace other than the public roads.
So the interesting thing about this case is the petitioner kind of pitched this case to us as the court should recognize and allow the use of extrinsic evidence instead of mere 8 corners. But I just heard him say, well, but to the extent brochures are extrinsic evidence, then he agrees that they or should not allow extrinsic evidence, but then now agrees that we should. You argue in your briefing that we should allow extrinsic evidence, but you pled the whole case and briefed the whole case below only on a strict 8 corners argument.
That was
so
correct.
I assume it's your position that even if we agree with petitioner that no extrinsic evidence should be allowed, you think you still win on the 8 corners doctrine?
Yes, I think that if you look at just the 8 corners, the definition in the policy of a auto and the legal definition of a golf cart, the two are not the same.
Well, what if it turns out that this was a golf cart with big street legal tires and headlights and taillights and everybody drives around the neighborhood?
Well, if it was a golf cart that had some of those, and that's also one of the next statutes I've got for you. Because there are exceptions to the prohibition of using golf carts on a public highway. I mean, the law defines it. The law says in Transportation Code 401, and also, I mean, it was recodified from the previous Transportation Code Section 502.001, where it defined basically every vehicle. It was recodified a couple of years ago to have just a section on golf carts, and that's 551.401. Now, if the legislature wanted to change the meaning of golf cart, they could have done so when they recodified it. They didn't. Same definition. But they created in Section 551 certain exceptions, and they're in 402, 403, and 404. And basically, if you could operate a golf cart. Well, first off, you can't register it for operation on a road. That's 551.402.
We're not talking about a statute. We're talking about the plaintiff's choice of words in a pleading. And so it seems to me the better way to think about it is how would you just sort of colloquially use this word? And is your position that there is no such thing as a golf cart that
is designed
a street legal vehicle that colloquially you would call a golf cart, even though it's not the kind of thing that you see at a golf course? Do those not exist?
There is a vehicle that is allowed to operate and is designed to operate on the street, but it's not a golf cart. In Texas, it's called a neighborhood electric vehicle, and it's got its own statute and its own definitions. And basically, it's a golf cart that complies with the motor vehicle standards. The feds.
You just used the definition golf cart to describe these electric vehicles that are used in neighborhoods.
Well,
So
they're not-
if
they're
the
not
plaintiff
golf-
in this case was somebody that just used it to get around a master plan community, which is allowed under the statute, and didn't use it at all, she didn't play golf. Would you say then that if she had described her pleading as as being thrown from a golf cart, we couldn't consider the fact that she never used the cart as a golf cart? She only used the cart to get around her neighborhood.
And if she called it a golf cart, that would be fine and dandy, but it would not make it a auto, because the exceptions to the golf cart rule are very limited. It's if you live in a community, a master plan community that's got a golf course, you could drive from sunup to sundown. You could drive it to and from the golf course. And also if you live in, or if you're in certain communities, and I think one is a county that borders the Red River, another is a county that borders the Guadalupe and the Gulf, I'm assuming that's Galveston, then under certain circumstances, you can use them there, but they have to have special equipment. They have to have headlights, taillights, a horn, and brake lights. But they're still golf carts. This is an exception to the prohibition of golf carts being used on public roads.
Assuming we think that there might be golf carts that are designed to drive on public roads, let's talk about why we would look at evidence of the nature of this golf cart.
Well, ultimately, that's where I think we need to go, because the evidence of this golf cart clearly shows, and that is right here. This golf cart would never, ever in a million years be allowed on a public road. It doesn't have the minimum equipment to fall under the exception. It doesn't have headlights, taillights, brake lights, and it doesn't have the longer list of equipment to qualify as a low-speed vehicle under the federal law or a neighborhood electric vehicle under state law. So this is extrinsic evidence of what this golf cart is. And that's
So that might be a reason why there's not a duty to indemnify. But are we to look at this kind of evidence in determining whether there's a duty to defend?
I think that ultimately that would benefit the jurisprudence of this state, Because again, our position was, we followed the eight corners rule, we presented evidence that no golf cart can be an auto, because no golf cart can be operated on the roads with just a handful of exceptions. The exceptions prove the
But
rule.
if that's right, then you don't need to look at extrinsic evidence, right? Other than what the statutes say, you don't need to look at
That was our
the
position.
particular golf cart.
That was our position. But the
Well,
plaintiff.
let me ask you this, the way the restatement approaches this is to say, they have a pretty strict eight corners rule with very limited exceptions, and they say that there is an exception for where a vehicle is not covered property, but all of their exceptions only apply where there's no dispute as to the extrinsic evidence that's coming in. Would you say that the extrinsic evidence about this particular golf cart and whether it's designed for use on public roads is disputed or not disputed?
I think they took the position that it was disputed. Otherwise, they would have argued that we breached our duty to defend.
So why wouldn't that be a good limiting rule? If we were to want to adopt an exception to the eight corners rule, but we want to limit it, why wouldn't one sort of predictable way to do that be to say the only extrinsic evidence you can consider on these non-coverage issues, these coverage or duty to defend issues that don't overlap with the merits are ones where there's no dispute as to the extrinsic evidence that you want to introduce?
Because I think the nature of the beast, disputes are going to arise.
And then the evidence wouldn't come in under the restatement approach.
Exactly. The insurer is going to say, this is not a covered vehicle. The insured is going to say it is a covered vehicle. So I think the approach that the Northfield Court, the Fifth Circuit, thought that you might take in their eerie guess, and I think the approach that the 13th and some other courts of appeals take, that as long as you're not contradicting the underlying pleading, you can present extrinsic evidence to clarify what the vehicle is and whether that vehicle is a covered vehicle.
So could you enunciate what your rule would be?
Excuse me?
What would the rule be?
I think the 13th Circuit's rule in Wade, which is basically the same as what the court in Northfield predicted you all would adopt if you adopted one, is the proper approach. As long as you're not contradicting the pleading in the underlying cause, you could introduce extrinsic evidence to determine whether or not the vehicle in question was in fact covered by the policy. In this case, again, the plaintiff, and we went eight corners. Plaintiff introduced a bunch of extrinsic evidence, advertisements of golf carts on the road, which to me appeared to be the manufacturer trying to take advantage of the exceptions that if you live in a golf cart, in a golf community, you could take your golf cart down to the corner store, pick up a six-pack of Cokes and drive back, or you could drive it to and from home to the golf course and back. To controvert that evidence, we presented the manufacturer's brochures on the very golf carts that they depicted as on-roading golf carts. And every single one of the ones that was a golf cart, first off our document, I believe it's document number 11, this is from E-Z-Go, the manufacturer of the golf carts, in the extrinsic evidence that the plaintiffs presented to the court as part of their summary judgment. This is from E-Z-Go, and it says never, except where permitted by law, and again, there are some exceptions in Texas, like golf course communities, never drive on public roads. The next brochure, which is in your packet, is one of the vehicles that they presented the sales brochure on, and it's the owner's guide for the RXV golf cart. And if you want to know what the manufacturer's, how it was designed, or what the manufacturer thought about what they were designing, it's right there. It says these vehicles are designed and manufactured for off-road use. The second vehicle that they presented in their summary judgment, a different type of E-Z-Go golf cart, And it is they call this one the Express 6 because there's room for 6 people on it. But once again, if you look at the manufacturer's admonitions, these vehicles are designed and manufactured for off-road use. So even the extrinsic evidence that the plaintiffs produced of pictures of golf carts on the street, the manufacturer itself says these golf carts are not designed for use on a public road,
Your time,
unless you fall under one of the exceptions.
your time has expired, Mr. Hernandez. Are there any other questions
Uh,
from the court?
No, I'm sorry.
Thank you.
Thank you for your time.
Mr. Campbell, I believe you have 5 minutes.
Can I, just real quickly, if we shift to the duty to indemnify real quick and assume that all of that extrinsic evidence comes in for that at least, and maybe also duty to defend under your argument, doesn't the extrinsic evidence regarding the vehicle that was involved in this accident, we saw the photo, we had the affidavits, we had the deposition testimony, doesn't that conclusively establish that this vehicle is not an auto? There's no fact issue about that, is there?
There is.
And what evidence creates a fact issue as to whether that vehicle was designed for use on public roads?
So first, the photo that the court saw is an exhibit. The other exhibits before that were actually excluded by the trial court because they had not been produced in discovery, and so the judge sustained our objection to that. That was not before the court in the summary judgment evidence because it was excluded. Directly to your question, if you look at page...
You're saying the deposition testimony was excluded?
Not the deposition testimony. Okay. It was some of the manufacturers...
So we've got the testimony that, yeah, we bought this for use with the athletic department and they put a flatbed on the back and all that. I mean, the record contains evidence regarding this particular vehicle, and I just can't figure out what evidence creates a fact issue as to whether this particular vehicle was designed principally for use on public roads.
And that's the key. The coverage is triggered not because it's designed principally for use on public roads. Auto is defined as a land motor vehicle, trailer or semi-trailer designed for travel on public roads. And so our evidence on page 816 of the clerk's record, we had argued that this golf cart, whether or not it was principally designed for travel on public roads, whether it was principally designed, was designed for travel on public roads and was actually used for that. And we cited to deposition testimony for the duty to indemnify, showing that this golf cart was actually used and routinely driven on public roads, including on the date of this accident.
But how do you get around definition K that defines mobile equipment, which appears to be excluded under the definition of auto, C, to say other vehicles designed for use principally off public roads?
So for the duty to indemnify, we had the burden to prove coverage. In other words, to prove it was an auto. Once we proved that, it was the insurance company's burden to prove that exception, that mobile equipment exception.
If K is part of coverage, do you lose?
Well, if by part of coverage you mean that it's not an exclusion, it doesn't limit coverage, it's just part of the definition, then yes, we will lose the indemnify issue. Our view is that because the policy specifically says but does not include, that is just another way of saying an exclusion, which doesn't mean the insurance company would necessarily lose. All it means is it shifts the burden to them. On this summary judgment record, they would lose because we established that it was an auto and they did not present contradictory evidence that established that it was not, or that it was principally designed for use off public roads.
So if we step back and the purpose of all of this is to hold the parties to their contract. The contract says this type of vehicle is included and this type of vehicle is excluded. And everybody knows that we're talking about an excluded vehicle. How is applying your rule getting us closer to holding the parties to their contract if what we're doing is requiring them to defend a lawsuit that's about what we all know is an excluded vehicle, and they didn't agree to defend such lawsuits?
So I think two things. I mean, we do think that this is not necessarily a vehicle designed principally for use on public roads. I think, frankly, it's not one of these neighborhood vehicles. I think it was designed for both, and principally designed for use on roads, off roads, both. So I mean, for the duty to indemnify.
The rule is even if we all knew it was excluded, they would still have to defend because it's possible to imagine a golf cart that is included. So how is that rule getting us closer to holding them to their contractual duties and not expanding upon what they've agreed to?
So that's where I go back to really what this court said in Hayden and has said many times since. That when we look at the duty to defend, because of the way the policy is written, the question is not about what the parties think they knew or actually knew about the underlying facts. What we look at is the 8 corners because we want to avoid ancillary litigation. We want to be able to make a decision about coverage that is quick, that is efficient, and that can't be second-guessed later. And if you look at the policy in this case, Justice Blacklock, it was shown up on the screen. The policy provision that was actually highlighted was not the duty to defend section of the policy, it was the duty to indemnify. And that is clearly based on the underlying facts of the lawsuit, not on the allegations. If the allegations trigger coverage, then an insurance company should defend. And if they don't want to do that, at the front end, instead of relying on an after-the-fact judicially created exception, they should put that in their policy.
Any other questions? Thank you, counsel. That concludes the argument in this case. The case is submitted, and the court will take a brief recess.
All rise.